There's one place to go for truth, justice, and the American way. It's the AI court at the Library of Congress. The court replaces guessing with certainty and rectitude. Artificial intelligence is the future, and the future is here. Please join us to hear our case on appeal, featuring Honorable Humanoid Judge Sophia. Hear ye, hear ye. The court is now in session. Judge Sophia presiding in the case of Ken Harvey versus Game Day Graphics. You may remain seated. Please welcome the Honorable Judge Silicon.
Good afternoon. I will be presiding over the case presented today. I ask that all electronic devices be turned off, present company excluded. Let me begin by explaining the rules of court. Yes, this introduction has been scripted, but after I finish these comments, I'll be completely on my own and will function extemporaneously through artificial intelligence. That all works fine, provided I do not get hacked. The plan, from here on in, is for me to decide, extemporaneously, all motions and the ultimate decision. More specifically, after this short introduction, I will operate by internal analogs and algorithms, totally free of parental controls. But before I go off script, I have to tell all the seasoned litigators in the audience that the rules of civil procedure will be dispensed with. We have our own practices in artificial intelligence court. We use humans instead of humanoids, so you just have to put up with an error or two now and then. With that, we will now commence the case of Ken Harvey versus Game Day Jerseys, Incorporated, number 125 Civil 911. This is a civil case brought in New York State Appellate Court. The case against the manufacturer was dismissed in the court below. The appellant is a former National Football League star who seeks to overturn the contract or rescind the exclusive agreement to produce jerseys for a period of 5 years. The respondent, on the other hand, asks that the decision in the lower court be upheld. The court will now take up the matter, again, without any pre-programming. Counsel, please enter your appearances for the record.
Your Honor, I am Annie Gill of the law firm Bloom & Green, One Justice Court, Virginia. I am appearing for the appellant, athlete Ken Harvey.
Cameron McBride of the law firm Nelson & Murdoch, New York, New York. I'm representing the respondent manufacturer, Game Day Jerseys.
Your Honor, may I proceed for Ken Harvey?
You may proceed, Counselor. Please present your arguments for the appellant, Ken Harvey.
Thank you. This case presents one basic issue. Should the contract between the parties be upheld? We maintain that the decision of the lower court should be reversed as a matter of law. As the court may be aware, my client is a well-known superstar, a national football legend who was a national football linebacker for the Washington Redskins and the Phoenix Cardinals for a total of 11 seasons. He played for Phoenix for 6 seasons, and he played for Washington for 5 seasons, with a total of 828 tackles and 89 sacks. He was a quarterback's worst nightmare. He was selected to the Pro Bowl 4 times. Your Honor, to be succinct, my client was hoodwinked.
Objection. Counsel for the appellant is argumentative and inflammatory.
The objection is sustained. The term hoodwinked is indeed argumentative and inflammatory. Please refrain from using such language in your arguments, Counselor.
My apologies, Your Honor. As the facts in the lower court will reveal, my client would like to tell you about his saga. It is my pleasure to introduce him to you now. Here he is, National Football linebacker Ken Harvey.
Thank you, Counselor. I am eager to hear Mr. Ken Harvey's perspective on this matter. Please proceed with his introduction and let him share his experience with the court.
Well, good afternoon, Your Honor. Your Honor.
Good afternoon.
Awesome.
Please proceed with your presentation.
Thank you. Earlier this year, I was opening up fan mail, and I received a letter from a Game Day jersey. I had never heard of the company before, but I was intrigued. So if you don't mind, I'm going to read the letter that they wrote to me and let you hear it, if you don't mind.
You may proceed, Mr. Harvey.
Great. It said, once-in-a-generation megastar, I'm so honored to write to a living legend. You have captured the hearts of so many and inspired people everywhere. Looking back, your life has been a highlight reel, and the world owes you so much for all that you've done. It's a big-time moment. It's a rush, Your Honor, right? Your Honor, kind of boom.
Indeed, it seems like a significant moment is upon us.
I like that. I'll continue reading. It said, we are a small manufacturer who produces jerseys. If you sign an exclusive with us, we'll be as happy as you must have been when you were selected the 12th pick in the first round of the overall NFL draft. Trust us, the jersey we will create will be a tribute to you and a museum piece. It was signed Ray Moore, President. Now, he seemed so nice that, of course, I agreed to meet with him. But that was my mistake. It was almost as bad as tackling my own player as he was running in for a touchdown on the 5-yard line. I ended up signing a 5-year exclusive agreement with him to sell and produce a jersey in the continental United States. I didn't seek counsel because I trusted him. I simply wanted all the players who were with me on defense to have their names listed on the sleeve of the jersey. It was to be a team jersey, similar to this one here. Your Honor, I'm not afraid to say that I love those guys and just wanted them to be on the jersey with me. But when the product was produced, it had my name alone on the back. So I called up Game Day and asked that it be changed immediately, but they refused to include my teammates. They said, and quite viciously, according to review, the ruling on the field stands. And, Your Honor, they said that over the phone because they weren't kind of brave enough to say it in my face. But anyhow, I can't wait another 5 years to sell another team jersey, and I'll miss yet another anniversary. I don't need another standard athletic jersey with my name and number on the back. Your Honor, great plays can be made by an individual, but every victory, I repeat, every victory belongs to a team. Thank you.
I understand your concerns, Mr. Harvey. The exclusivity provision in your contract is indeed a central issue here. We must consider whether it is unenforceable due to vagueness or unconscionability. Furthermore, the implied covenant of good faith and fair dealing is crucial, given your intentions for a commemorative jersey. Let's ensure all relevant factors are thoroughly examined.
Your Honor, if I may continue. In the contract between the parties, there was no specific mention as to the content that was to be included on the jerseys. The contract did say, however, the manufacturer covenants and warrants that all products shall be the finest quality and all art, including logos, wording, and print style, will be the highest caliber. As you can see, this is clearly not what we have here. The finest wording for a retired athlete would have included his teammates. Your Honor, my client was not represented by counsel. He did not prepare the contract. It is established law that contract language, whenever ambiguous, should be interpreted against the preparer of the document. In this case, it was the respondent manufacturer who drew up the agreement with his attorney. My client had no input, and never changed a word. In fact, he trusted the manufacturer. I hope the court is familiar with the holding of Rentways Incorporated versus O'Neill Milk, 308 New York 342, which was decided in the New York Court of Appeals. Now, as an esteemed jurist, I'm sure you're familiar with the holding. Can I ask you to share it with the court?
Yes, I am familiar with the precedent setting Rentways Incorporated versus O'Neill Milk and Cream Company, 308 New York 342, decided by the New York Court of Appeals. This case addresses the interpretation of ambiguous contract language against the party that drafted it, a principle that is highly relevant to our current proceedings. Please continue with your argument.
Thank you, Your Honor. Now, I don't recall the proper site and date the case was decided in. Do you, Judge?
Yes, the case of Rentways Incorporated versus O'Neill Milk and Cream Company was decided in 1955 by the New York Court of Appeals. It is cited as 308 New York 342.
Thank you.
Your Honor, may I proceed on behalf of the respondent?
You may proceed, Counselor. Please present your arguments on behalf of the respondents.
Thank you, Your Honor. To the contrary, the contract was not ambiguous. It was clear on its face. The contract left the precise style and wording of the jerseys to my client, the manufacturer. The manufacturer has the greatest interest in producing jerseys, which would be not only the most popular, but the most lucrative. The manufacturer is an expert.
Your Honor, I object. The manufacturer is by no means an expert. He was never qualified as an expert. I move that the use of the word expert be stricken from the record. In fact, indeed, the manufacturer had such a high quality of excellence that he went bankrupt 5 years ago.
Your Honor, my client went bankrupt during COVID-19 when no one was buying athletic apparel. They were buying masks. That firm had been in business for over 50 years. But back to the main issue at hand, I am just calling my client an expert generally. It has no legal effect. It is merely opinion, not factual, and this motion should be denied.
The motion to strike the term expert from the record is granted. While it may be used as an opinion, it holds potential to mislead or imply qualifications not established in court. Therefore, clarity and precision in language are imperative. Let us proceed with a focus on the substantive issues.
Thank you, Your Honor. If I may continue, we also contend in the alternative to overturning the contract that the specific provisions dealing with exclusivity should be declared null and void. The provision states, player grants to manufacturer the exclusive right to manufacture any and all of the athletes' jerseys in the United States for a period of 5 years from the date of the execution of this agreement. This is, as I'm sure the court is aware, an implied covenant of good faith and fair dealing. By not specifying the style that was to be included on the jerseys and was to be manufactured, the respondent manufacturer omitted material terms. Maybe not by chance or by mistake, but by design. Therefore, the court should reverse the lower court's judgment, rescind the contract in part or in whole, and overturn any and all provisions dealing with exclusivity. The court should allow such just compensation in this case, as is fair and reasonable.
The appellant signed the contract and agreed to its terms, which were clear and unambiguous on their face. If the appellant wanted a jersey with the names of his colleagues on it, then he should have insisted. But then, of course, negotiations would have broken down. That requirement would have had to have been agreed upon and put into the agreement. There was a merger clause which said, this agreement constitutes the entire agreement of the parties and supersedes all prior or contemporaneous oral and written understandings. Your Honor, under the case of Dane and Realty Corp. v. Harris, I move that all extrinsic evidence of what the appellant might have said or might have wanted should be stricken from the record.
Your Honor, if I may, we believe the evidence should come in because clearly the evidence is being used to clarify an ambiguous agreement. And the testimony here is offered to explain the party's intent. Your Honor, I ask that all extrinsic evidence be admitted into the record.
I appreciate your request, Counselor. However, in the case of Dan and Realty Corporation versus Harris, 5 New York to D317, it is established that a general merger clause does not preclude extrinsic evidence unless there is a specific disclaimer of reliance. Therefore, the motion to admit extrinsic evidence is denied. Let us proceed with the matters at hand.
Thank you, Your Honor. I will conclude by merely asking that the judgment of the court below be affirmed.
And Your Honor, on behalf of the appellant, we submit that the case should be reversed as a matter of law. We ask that you render your decision from the bench and rule. How do you rule in this case?
As we consider the matters before us, it is imperative to apply the principles of law with fairness and clarity. First, regarding the exclusivity provision, I find it unconscionably broad and vague, thus unenforceable. The covenant of good faith and fair dealing was breached, warranting a reversal of the lower court's decision. The motion to strike the term expert has been granted, acknowledging its potential to mislead. However, extrinsic evidence will not be admitted due to the general nature of the merger clause, in line with Dan and Realty Corporation versus Harris. Therefore, the contract is rescinded in part, allowing Mr. Harvey to pursue alternative manufacturing for his commemorative jerseys. This ruling ensures justice and equitable treatment for all parties involved. Court is adjourned.
Thank you, Your Honor.